Hey guys, welcome to my channel. I was really hoping that this video was going to be short, but as I sort of went through this case, I realized that was not going to happen. This case just gets kind of interesting because one of the basic rules, I think, when you go into court is who is the other party? And in this case, they wanted to use initials because, well, it was just, a subject matter that people wanted to be able to not make so public. Hi, my name is Sheila. Welcome to my channel. This particular case is out of Kansas, and this is Geico and Government Employees Insurance Company versus MO and MB. So yes, they are actually identified by the initials. And as I was stating before, that's usually not how we do things, right? Most of you are probably familiar with the concept that, hey, I'm supposed to be able to know who's suing me so that I can actually put together a case against the other party. It's not like Geico didn't know who the defendant was because one of the defendants was actually Geico's client. So the parties knew who they were. So you might be wondering, well, Sheila, why did they use initials? Did the court let them get away with this? And is this something that I can do in the future? Can I just use my initials so that I can not have my name all in the public record? Well, we're gonna talk about that. Let me just say up front, YouTube is probably going to censor this video to some extent because of the nature and context of what we're going to be talking about. Basically, Geico's client had car sex with another person, okay? Let me put on my glasses because I want to make sure I get this right. All right, this is the actual issue here, okay? I want to go over this so that we make sure we understand what's going on. So Geico is seeking what's called a declaratory judgment. They want to hear the court's opinion on this. A declaratory judgment to determine Geico's rights and obligations for its insured allegedly spreading a sexually transmitted disease while voluntarily having unprotected sex in the insured's automobile. Geico's insured is defendant MB, and he allegedly gave the STD to defendant MO. MO demanded that Geico pay her $1 million to resolve her claim against MB, triggering Geico to file this lawsuit. When Geico filed this lawsuit, it named defendants MO and MB by their initials. So Geico, wants to go to court and say, hey, do I have to pay this person? Do I have any obligations here? But given the nature of how this all came about and how we sometimes really do try to make sure that we're protecting parties in certain situations, we're going to be careful here and we're just going to use their initials. So that's what Geico thought was the best thing to do at that moment in time. The court then said, hey, I want you to show cause as to why Geico should not be required to file an amended complaint that names defendants by their full names and to state what corrective action might be necessary to take care of any defects in regards to subject matter jurisdiction. I don't want to get too deep into that part, but the court is basically saying, hey, come to court, tell me what's going on and why you should not have to actually use their names and not these initials. We don't use initials in court filings. Let's give some background here, all right? So according to the filings in this case, and this is directly coming from, our pieces of paper here. According to the filings in this case, MO and MB began having a sexual relationship in November and early December of 2017. This included having unprotected sex in MB's 2014 Hyundai Genesis. Okay, so I was not really familiar with what a Hyundai Genesis was. I actually looked it up for those of you who are interested in knowing what that car is. There you go. MO alleges that MB had been previously diagnosed with anogenital human papillomavirus, basically HPV, which is highly contagious through sexual contact, but he did not tell MO about it or take measures to prevent transmitting the virus to MO. Okay, full stop right here, because I know what some of you are thinking. She could have taken steps to protect herself, right? That is correct. Right now, we're just going through the background. I'm not making any assumptions on who shoulda, coulda, woulda, okay? We're just going through the background that's in the actual court document. Guys, don't get mad at me. So then it says, at MO's regularly scheduled gynecological exam in November 2018, she was diagnosed with anogenital HPV. She later learned that she contracted the virus from MB. All right, so MB actually had two policies, this Kansas automobile insurance policy and that listed MB's Hyundai Genesis and an umbrella policy. Okay, so MO sent Geico a demand letter. Here's the thing, MO was asserting claims for negligence and negligent infliction of emotional distress. Negligent in his actions, not intentional, okay? Intentional would be that he meant to give her to it. Negligent would have been, you should have worn a condom, okay? It referred to both, this petition for damages, referred to both MO and MB by their initials and stated that plaintiff is referred to in this public filing by pseudonym name to maintain confidentiality of her identity. So let me go back. February 25th, 2021, MO sends Geico a demand letter. She uses the pseudonyms. Geico then finds out, well, wait a second, what's going on here? Because, you're sending us something saying we owe you money. How did we get to this point? So Geico starts to learn what's going on. And they're like, wait a minute, it sounds like there's some defenses that we had that we didn't know about. And we don't even know what's going on here. We're coming in late to the game. For example, as Geico is sort of investigating what is going on here, MB said that he told MO on 3 different occasions that he had been diagnosed with HPV positive throat cancer. That MO, okay, this is the second thing, that MO had sexual partners other than MB during this period of time, and that the two had sex in locations other than the vehicle, meaning, Geico might not have to pay here. That MB had never been diagnosed with HPV before 2017, and that another physician told him that he didn't have it, okay? Did he or didn't he? So there's like all of these defenses out here that Geico's saying, wait a second, full stop here before we write you a check. On or about March 11th, MO and MB entered into an agreement to settle MO's claim. Under this agreement, they sort of came together and said that the plaintiff may collect the settlement only against the insurer, Geico. So they're both of those people who had sex have now said, all right, well, if there's somebody who's going to be sued here, whatever arrangement we have, but hey, the settlement's only going to come from this insurer. As a result, this agreement limited MB's liability to MO, okay? So he doesn't have to pay her, like that's limited. MO can go after Geico. So Geico says that it did not know at the time that MO and MB had entered into this agreement. Geico files this declaratory judgment using initials. The next day, Geico then files an amended complaint asking the court to file under seal a reference list identifying the defendants by their full name, unredacted versions of the insurance policies, etc. Okay, so the complaint still has the initials in it, but then Geico amends the complaint to include some information under seal so that it's not public, which actually has the full names. So that information is now sort of there, okay? Now, Geico is basically in a position where it's on the hook now. And it's saying, hey, I didn't know that there was an arbitration, because that's what they find out. Geico says that it did not know at the time that MO and MB submitted MO's claim against MB to arbitration on May 17th. The next day, the arbitrator awarded MO a $5.2 million arbitration award against MB. That is a lot of money. On May 24th, MO filed suit in Jackson County Circuit Court, asserting claims against MB for the negligence and the negligent infliction of emotional distress, like I mentioned earlier. It was at that time that Geico first learned about this whole agreement that they had where she could go sue Geico, and about the $5.2 million arbitration award that MO can collect, if at all, from Geico, and only from Geico. All right, so Geico says, no. Okay, this secret arbitration was a sham. It was collusion. They got together to put us on the hook here. All right, they say, according to Geico, MO and MB kept the arbitration a secret to avoid Geico's right to intervene and be heard, to fix liability where it otherwise would not attach, and to obtain an artificially inflated award, all in an attempt to pursue insurance proceeds and extra contractual monies from Geico. Geico says MB must not have presented any substantive defense to MO's claims during the arbitration. All right, so after Geico files, MB files an answer. MO has not yet answered. Instead, she moved to dismiss Geico's claim. She goes, hey, she lacks sufficient minimum contacts in the state of Kansas, which is, again, where I said this was. She contends that she engaged in unprotected sex with MB while in the car in Missouri, and that she filed her state court lawsuit against him in Missouri and not in Kansas. Geico, of course, says MO has sufficient minimum contacts in Kansas because she demanded that Geico pay on behalf of this Kansas resident. So since the guy she was suing lived in Kansas, he's like, Geico's like, yeah. No, you're already in here. You're already touching Kansas. You've got some contacts going on. No. Furthermore, it says it's a Kansas auto insurance policy, and you're seeking to enforce the coverage and garnish on a Kansas auto insurance policy issued to a Kansas resident. And they say that they are pretty much standing in his shoes, and therefore she cannot dismiss because she does have enough contact with the state of Kansas in order not to have the suit dismissed. Here's the other thing. It says MO claims to have contracted HPV from having sex, but apparently some of it took place in MB's house in Kansas and in this automobile, which is licensed, titled, and garaged in Kansas. So even though there were these times when they were in Missouri, apparently they spent some time in Kansas too. Geico's alleging this is enough contact, and the whole contact thing is just feeling like a pun here with me. So yes, so it says on July 2nd, the Jackson County Circuit Court granted Geico's motion to intervene. Hey, you can now step in, confirm the arbitration award, and enter this $5.2 million judgment. The court is now at this point where it's saying, okay, all that's going on, but I'm issuing a show cause order to address this issue of defendants proceeding by their initials. We get there's all this other stuff going on, but this is not generally allowed under federal rules of civil procedure. On July 30th, the court entered that order to show cause. The court pointed out that Federal Rule of Procedure 10A requires the title of the complaint to, quote, name all the parties, unquote. The court explained that the parties must petition the court to proceed anonymously, or absent permission, the court lacks jurisdiction over the unnamed parties. Court's like, you either name them or we can't go forward because there is no jurisdiction over whoever this is. We don't even know who it is. Okay, so here's the rule. So court said, hey, you need to come in and tell us why, or you need to amend the complaint with the full names. All right, so MO and MB responded to this show cause order and moved for leave to proceed by their initials. Okay, so they said, hey, Here's our response, and we want to keep using our initials. Geico is stating, hey, we don't object to that, okay? Geico states that it does not object to allowing MO and MB to proceed anonymously and seeks only to respect defendants' previously stated interest in privacy to the extent permitted by law in this court's discretion. Why? In a footnote, Geico further explains that it wishes to avoid any conduct such as publicly disclosing defendants' identities because it is concerned that MB may later argue that this constituted bad faith on their part. And they don't want that used against them, right? They are trying to get out of this $5.2 million settlement, not have it be reaffirmed by another court. Geico takes the position that, hey, allowing MO and MB to proceed anonymously does not impact the court's subject matter jurisdiction. So the court says, hey, okay, all right, we get it. We're talking about the sensitive nature of the allegations here. And Geico used the acronyms because it did not wish to unnecessarily infringe on their privacy interests. We get it. One of the things they said was, hey, the court allowed us to have this sort of provisional permission when we disclose the identities under seal. So it's not that the court doesn't have it, it's just under seal. And so Geico says, hey, we contend that this court therefore has subject matter jurisdiction because the parties' real identities are known to one another. We all know who we are, and the court knows who we are, okay? And that therefore there's no additional action that's needed to perfect jurisdiction. Well, okay, so right about now, you're like, okay, so if they can proceed with their initials, can I proceed with mine in case, I'm ever in this sort of situation? All right, we're gonna get there. So the court then goes through the rule, and I said that before. There are a number of cases listed here. It says, absent permission and under such other circumstances as the court may impose, the federal courts lack jurisdiction over the unnamed parties. And they just go through case, showing that that is the rule. Just because their identities are known does not mean that jurisdiction exists. Like, you're still not meeting the requirement of the rule, is what the court said. A party that wants to avoid dismissal should seek leave to proceed anonymously early in the case or risk dismissal. In this particular case, Geico had no skin in the game, so to speak, as to whether MB and MO should be allowed to proceed anonymously. Now, remember, I just said Geico said, well, we don't want to look like it's bad faith on our part, right? So they did feel like they had skin in the game. Court said, we don't think so. It's not you that's going to be injured if their names are revealed. Says Geico was simply trying to respect their apparent desire to veil their identities from public disclosure, given the sensitive nature of the allegations. Under these circumstances, the onus should be on MB and MO to obtain the court's permission to proceed anonymously. Yet they were not served, nor did they appear in the case until after Geico filed the case. So now they've both, of course, moved to say, can we proceed anonymously? Let's sort of break this down as to when you can do this and when you can't. So the court turns to the issue of the extent to which a defendant or defendants should be allowed to proceed anonymously. Federal rules of civil procedure do not contemplate non-minors proceeding anonymously or by initials. We get that. Kids, children, minors. We want to protect their identities. Court must weigh the movant's privacy interest against the public's interest in open court proceedings. So basically, this is about it being transparent for the world. So we're going to talk about both of these. The public's interest in open court proceedings. Courts recognize the public's general right to inspect and copy public records and documents, including judicial records and documents. You go down to the courthouse. Well, can I get a copy of my deed? Yep. Can I get a copy of a lawsuit? Yep. Can I get a copy of my tax records? Yes, you can. All those things are public records and you can get a copy of them. What transpired? This is from one of the cases. A trial is a public event. What transpires in the courtroom is public property. Okay, it's not looking good for MO and MB, right? This includes a public interest in knowing the litigants' identities. Identifying the parties to the proceeding is an important dimension of publicness. The people have a right to know Who is using their courts? You guys, this is a case out of 1997. Next up, and although certain factors may heighten the public's interest, such as cases involving public figures or public funds, the public's interest in routine court proceedings is still significant. But as one court observed, there is a significant interest in open judicial proceedings, even in ordinary civil litigation between private parties, which is exactly what we have here. Something very ordinary and something very private. Because private civil suits individually and certainly in the aggregate do not only advance the party's private interest, but also further the public's interest in enforcing legal and social norms. Although this case does not involve the use of public funds or public figures, the public's interest is still significant. Here's the thing. It says, this is what the court really sort of starts to rely on. MO and MB try to characterize this case as one involving personal and intimate details of their sexual relationship. Okay, but the court's like, no. That is not what that is. This does not accurately characterize the nature of the case. So what is the case? The court says the case is now an insurance coverage dispute where the auto and umbrella coverage policies at issue appear to be like many others. And this case presents novel and potentially important issues about whether an insurance carrier can be held liable under such policies for the consequences of two adults voluntarily having unprotected sex in the insured's automobile. They say this has far-reaching implications for other policies with similar terms. Relevant issues like causation and the extent of MO's damages, whether MO's infection was caused by MB. And because the two engaged in unprotected sex, it is disputed whether MO knew that MB had HPV. There could be issues as to MO's fault. Apparently, there are issues as to where the sex occurred, in the car, in the home, other locations, raising the issue of when the virus was actually transmitted. Geico says that MB raised none of those issues during that arbitration. And the court says, hey, this is new stuff here. It's might be important to people to know about. Furthermore, any allegedly private details become less private when MO sent the demand letter to Geico making an insurance coverage claim. By doing so, she brought any arguably private matters into the public domain. So actually, she took something that was private and she made it public. Nobody would have ever known about it if she didn't try to make an insurance claim with it, right? Then it says they entered into this agreement whereby Geico was now going to be on the hook for $5.2 million, and she can only get it from Geico, not MB. Again, if it had been MB, they could have kept it private, right? In general, the court is saying parties who assert damage claims should expect some level of public exposure in employing the courts to resolve their dispute. What they're saying is, if you settle it outside of the court, it's private. It's all on you. But once you bring it into the court, what do you expect? Okay, what do you expect? There is going to be some level of public exposure here. Plaintiff has chosen to bring a private matter into the public eye. What about their privacy interests? Yes, this is a highly sensitive and personal matter. Significant privacy interests, such as plaintiff's interest in keeping their sexual habits from public scrutiny. Courts typically afford heightened protection to parents prosecuting claims on behalf of minor children who were allegedly subjected to sexual misconduct or harassment. We totally understand that we want to protect those children. Highly sensitive. Then the court says, hey, here's a case where they protected a minor. Let that minor use a pseudonym after reaching the age of majority because the allegations of sexual harassment by a popular football coach occurred when the child was a minor. Even though by the time the case went to court, the child was now of age of majority. It happened when that child was a minor, so they were going to continue to use a pseudonym. There is no bright line rule. Sexual behavior or preferences that are considered conventional or within the bounds of societal norms are generally accepted without controversy, ridicule, or derision, and therefore present a less compelling reason to proceed anonymously. Well, the court's saying there was nothing strange about what was going on here. Okay, you guys just had regular car sex. The court has difficulty finding that allegedly transmitting HPV while two adults voluntarily have unprotected sex is anything but commonplace. People do it all the time, in other words. Commonplace adult sexual behavior without more does not present the exceptional case justifying restricted public access. The court's really sort of saying this might be embarrassing, but it's not exceptional. Then finally, the court sort of says, okay, this whole thing is not about a sexual relationship anyway. It is an insurance coverage dispute. While many people would prefer to keep details about their sex lives private, the 10th Circuit has repeatedly made clear that the risk that a party may suffer some embarrassment by being named in the pleadings is not enough to allow them to proceed anonymously. Guys, so you're getting the rule now, okay? You're hearing me say this. Yeah, you're going to have some sort of exceptional circumstance in order to proceed anonymously. So that whole thing where you were thinking you were going to hide by your initials, no, that's a no-go. That's not going to happen. The risk that a plaintiff may suffer some embarrassment is insufficient to permit anonymity. Therefore, the court examines the record to see whether it reveals something more that would make this an exceptional case. And here, MO is saying, well, my minor children would suffer potential emotional and psychological harm. The court then says, hey, the mere fact that a parent's sex life might be embarrassing to minor children is not an exceptional case warranting anonymity. MB says it's going to subject him to social shame, ridicule, embarrassment, and humiliation that could devastate his employment, professional relationships, family, life, jeopardize his future political and personal opportunities, and provoke further unwarranted and resource-consuming investigations. But the court's just like, no, you don't even provide any facts showing that any of these things matter. Do you have a future political prospect here, or are you just naming these things? What additional investigations would be prompted by disclosure of their identities? What future opportunities would be impacted? Or if the nature of the relationship makes it more scandalous, for example, if one or both were married, if they had a supervisor-employee relationship or other special circumstance. Like, none of this is listed. And court's just like, you just can't throw this stuff out there. Can you give me something more? While courts have recognized that reputational harm or social stigma may exceed embarrassment and present a compelling reason to proceed anonymously, they have done so only when the moving party makes sufficiently particularized and supported showing of reputational harm or social stigma to justify the request. So in other words, MB, you can't just list those things and say, well, it might harm me here and all of these things. No, you've got to be a little bit more specific. Actually, I think the court wants you to be a lot more specific. Furthermore, courts are generally disinclined to allow parties to proceed anonymously if their identity has already been disclosed publicly or in court filings. Conclusion: MO and MB have not established that this is an exceptional case to allow them to proceed anonymously. MO and MB have come forward with only conclusory assertions of harm from disclosure. None of this rises to the level of anything except embarrassment. Plus, any remaining privacy interests the movements have do not outweigh the public interest in open court proceedings. So there you have it. So if you plan on going to court and using your initials, just know that you have a high bar to cross. People, that's it. That's pretty much it. That was a lot of paperwork for that. Again, Geico out of Kansas. Gotta have your full names. Gotta have your full names. All right, don't forget to subscribe to the channel, like the video. We'll talk about some more cases soon.